1979, also known as Presidential Decree 1612, defines and punishes fencing, or the act of any person who with intent to gain for himself or for another shall buy, receive, possess, keep, acquire, conceal, sell, or shall buy and sell an item which he knows or should be known to him to have been derived from the proceeds of theft or robbery. However, this does not apply to other crimes of gain, such as estafa. Fencing is a malum prohibitum, and PD 1612 creates a prima facie presumption of fencing from evidence of possession by the accused of any good, article, item, object, and/or anything of value which has been the subject of robbery or theft, and this prescribes a higher penalty based on the value of the property. Section 6. The clearance or permit to sell or use second-hand articles. For the purpose of this Act, all stores, establishments, or entities dealing in the buy and sell of any item of property owned by the government of the Philippines or any good or article, item, or object of anything of value obtained from an unlicensed dealer or supplier thereof shall, before offering the same for sale to the public, secure the necessary clearance or permit from the Chief of the Philippine National Police in the town or city where such store, establishment, or entity or government property is located. The PNP shall promulgate such rules and regulations to carry out the provisions of the said section. Any person who fails to secure the clearance or permit required by this section shall upon conviction be punished as a fence. Now here are the essential elements of the crime of fencing. First, a crime of robbery or theft has been committed. Second, the accused, who is not a principal nor an accomplice in the commission of the crime of robbery or theft, buys, receives, possesses, keeps, acquires, conceals, sells, or disposes, or buys and sells, or in any manner deals in any article, item, object, or anything of value which has been derived from the proceeds of the crime of robbery or theft. Third, the accused knew or should have known that the said article, item, object, or anything of value has been derived from the proceeds of the crime of robbery or theft. And lastly, there is, on the part of one accused, intent to gain for oneself or for another. And lastly, there is, on the part of one accused, intent to gain for oneself or for another. The penalty of reclusion perpetual or life imprisonment shall be given if the value of the property stolen is more than 100,000 pesos. The penalty of reclusion temporal and its minimum and maximum periods will be given if the value of the property stolen is more than 50,000 pesos but not exceeding 100,000 pesos. The penalty of prison mayor in its minimum and maximum periods will be given if the value of the property stolen is less than 50,000 pesos. Take note that the accessory penalty pertaining thereto as provided in the revised penal code shall also be imposed. This video is in partial fulfillment for our requirements in the course Criminal Law 1 under the supervision of Attorney Annabel C. Mindalano here in MSU IIT College of Law. We hope that you have learned from us, and you can browse through our channel to learn more about the special penal laws presented by the first year Fernandos. Thanks for watching, and good luck, future lawyers!